Good afternoon. My name is Matthew Fraser. I'm a barrister at Landmark Chambers. This is a case law review of the year in respect of SEA and EIA cases. It's been quite a busy year in respect of this area of law. I've counted 11 different cases that have been through the courts in the last 12 months or so, majority of which are in respect of environmental impact assessment as opposed to strategic environmental assessment. But starting with SEA, the first case is called Ebra. This was the challenge under section 113 of the 2004 Act to a development plan document in Leeds. The plan contained a number of housing allocations in the Greenbelt, and part of the justification behind those allocations was housing need, a significant amount of housing need, thereby contributing to exceptional circumstances. Now, the problem was that while the plan was in the process of being examined and towards the end of the plan being examined, it emerged that a new methodology was going to establish a much lower housing requirement than had been first thought. Now, the plan was subsequently adopted on the basis of the higher requirement, and the inspectors were challenged on a number of grounds, and indeed the local planning authority who adopted the plan. And it was argued that there'd been a breach of the SEA regs by failing to consider and consult upon the reasonable alternative of suspending the plan, i.e. saying you shouldn't proceed with this plan given the emerging new methodology, therefore you should suspend it pending the finalization of that, of whatever the housing requirement is. And in respect of this particular ground of challenge, the court held that it was indeed a reasonable alternative to consider suspending the plan. However, it was so obvious that there had been no prejudice arising from the failure to consult in relation to it. And as it happened, the claimant in that case had made representations seeking suspension in any event. And so the court held that even if the error had not occurred, the outcome would have been exactly the same. So it was unlawful, but no relief granted. That said, the plan was quashed on other grounds which don't relate to SEA. The second case I want to talk about, again, it's an SEA case, is the very well-known decision in Plan B Earth, the Court of Appeals decision. This was a challenge to the government's national policy statement for a third runway at Heathrow. And there were a huge number of different grounds being considered, and some of them related to SEA. And there was a claimed breach of the directive by firstly failing to give an outline of the relationship between the national policy statement on the one hand and other relevant plans and programs, and then secondly a failure to identify the characteristics of areas likely to be significantly affected by the third runway. And there was a separate claim that was pursued by a different party that the Paris Agreement was a relevant environmental protection objective at an international level for the purposes of Annex 1, Paragraph E of the SEA Directive, and that there had been a failure to take the Paris Agreement into account. And the court held, well, before it got to the specifics of the particular case at hand, it gave very important guidance as to the court's, the proper approach that the court should take to considering whether an environmental report complies with the SEA directive. And it was held that that approach has to reflect the breadth of the discretion that's given to a local authority in deciding what information is reasonably required. And accordingly, because of the breadth of that discretion, the Wednesbury irrationality standard of review is appropriate. And when they applied that test to the facts at hand, it was found that, at least on the first claimed breach of the SEA directive, that there was no such breach. However, in relation to the separate claim relating to the Paris Agreement, the court upheld the claimant's argument and said that it was an obviously relevant environmental protection objective that should have been, but wasn't taken into account in the environmental report. So, but it's worth noting that that particular issue, the separate claim, is currently the subject of consideration by the Supreme Court. The Supreme Court have held the hearing, but judgment is awaited. So that is the roundup in respect of SEA. I'm now going to turn to environmental impact assessments, so project specific. And the first case I want to look at is called Hayden against Shropshire. This was a challenge against the grant of planning permission for sand and gravel aggregate extraction in the Greenbelt. And again, one of a number of grounds brought before the court was a challenge relating to a breach of the EIA regulations as to a failure to require a further hydrological assessment due to alleged significant effects on groundwater by the development. And it was one of those cases where the claimant had not correctly interpreted what the officer's report was saying. The court held that, read fairly, the local authority's report indicated that it agreed with both the Environment Agency and the applicant's consultants that there would be no likely significant effects on groundwater. The court gave some interesting observations in relation to the status of the Environment Agency and the relevance of that agency agreeing. They said, given the agreement of the Environment Agency, which is expected to be competent on matters relating to environmental impact assessment, it was rational for the authority to have concluded no likely significant effects. And the court drew, in my view, an important distinction between a consultee such as the Environment Agency, on the one hand, questioning levels of assurance, which would not necessarily lead to a substantive objection to the scheme, and further than that, and distinctly from that, a conclusion of likely significant adverse effects in any particular given case. Kenyon is the next case I want to consider. This was the relevant decision under challenge in this case was a screening direction by the Secretary of State that residential development of less than 150 homes that lay near an air quality management area was not EIA development for the purposes of the EIA regs. The claim was that the Secretary of State, in concluding such, had failed to consider the cumulative effects of the proposal taken together with other sites in the area. The High Court dismissed the claim. The Court of Appeal subsequently dismissed the appeal, which was brought on a number of wide-ranging grounds. The judge who gave the lead judgment in the Court of Appeal, Lord Justice Coulson, was strident in his hostility towards the way in which the appeal had been brought. He said at paragraph 2, "I wondered if the most important point to arise from the appeal hearing was the need to ensure that appeals in cases of this kind do not become another weary trot around a well-worn course." The learned Lord Justice also made some very important observations about the need for parties to avoid making references to material that were not available to the decision maker at the time of the screening direction, that such material should be ignored. The court further held, in respect of the particular challenge to the screening direction, that the reasons in the direction, albeit brief in this case, were rational and adequate, particularly in view of the fact that this wasn't a difficult or borderline case. And that included in relation to the particular issue at hand, namely cumulative effects. The claimant also relied on what's known as the precautionary principle, which is a principle which is applied frequently in environmental contexts. And it was held importantly, again, by the court that such a principle has relevance, but only where there is some reasonable doubt as to the effects in question, and that was not the case here. The next case I want to look at is Client Earth against the Secretary of State for Business, Energy and Industrial Strategy. This was a challenge to the grant of a development consent order for the construction and operation of 2 gas-fired generating units at Drax Power Station. And the claim included, among many other grounds, again, ground 6, I believe, was the challenge to that there'd been a non-compliance with the infrastructure planning EIA regulations, particularly in relation to a failure to consider imposing monitoring measures on greenhouse gas emissions and other matters, but most importantly, greenhouse gas emissions. And what the court held, dismissing this particular argument, was that there was no specific duty to give reasons in respect of monitoring. There are, of course, a duty to give reasons generally, but there was no duty in respect specifically of monitoring. And the judge found it material that nobody throughout the examination had once suggested that greenhouse gas emissions ought to be monitored, and that the reason for this was palpably clear, and that was because there was a separate regulatory regime in operation, namely the emissions trading scheme, pursuant to which the applicant would separately need to obtain a greenhouse gas permit, and that whole process would enable greenhouse gas emissions to be separately monitored and indeed controlled. And the court had regard to the fact that there's an anti-duplication provision in Regulation 21(3)(c) in respect of monitoring measures, basically saying that you shouldn't, in the EIA context, impose monitoring measures where these are available under some separate applicable regime. The court held that even if there had been an error of law, there was no prejudice to the applicant. XSWFX is the next case I want to talk about. This was, it's important to bear in mind at the outset that this was only a permission decision. It never went further than the grant of permission to bring judicial review, and we'll get onto that shortly. But this was unusually not a challenge against the grant of planning permission, but a challenge against the discharge of pre-commencement conditions for the redevelopment of Warren Farm, which is a tract of metropolitan open land in West London. And the planning permission authorised the redevelopment of a training facility for Queen's Park Rangers, the football club. And the conditions at issue were ecological pre-commencement conditions that had been discharged. And the claim was that there'd been a failure to consider whether, in discharging those pre-commencement conditions, environmental impact assessment was required. And this was in circumstances where the original grant of planning permission had not had an EIA undertaken. So the court, there's an interesting outcome, at least in the permission decision, which is that the court held that there is indeed a requirement to screen for EIA that applies to subsequent applications, see regulations 5 to 9, and that includes applications under a condition attached to a grant of planning permission. And in any event, there's a separate obligation to keep under review screening opinions in respect of developments. The council in this case, perhaps unsurprisingly, accepted that it had indeed failed to screen for environmental impact assessment before discharging conditions. However, what it tried to say in defence was that it was highly likely that even if it had screened, it would have screened out the project as opposed to required an environmental statement. And this was rejected by the court. And essentially what the judge did was to examine the ecological evidence that had been submitted by the claimant. They looked at it and said, as a result of this evidence, which is conflicting with the evidence supplied by the defendant, it cannot be said by the court that it's highly likely that a screening opinion would have been negative. It's just not possible to say on the basis of the material, and thus permission was granted. As I said at the outset, this is only a permission decision. The claim was subsequently conceded and the defence was not pursued. I understand that's because the football club had decided to pursue an alternative site. The next case is Swire, which has some local interest for me because it's based on a site only about 5 minutes away from where I live. This was a judicial review of a negative, again, another screening direction challenge, a negative screening direction for a 20-home development. And you might think 20 homes, why is that remotely significant in terms of environmental impacts? Well, the site in question was unusual, highly unusual, in that it was one of only 4 sites in the UK that had been used for the disposal of cattle infected with mad cow disease. And again, quite surprisingly, the developers' reports that dealt with contamination issues that had been submitted to support the planning application did not make any reference whatsoever to this slightly alarming former use. There was then a resolution to grant outline planning permission, and there were conditions attached to the planning permission requiring contamination to be assessed and remediated. And the screening directions said that effectively, because of those contamination related conditions, the project could be screened out of EIA because all the problems in relation, or if there are any problems relating to mad cow disease arising from the site, then they could be dealt with by way of condition. And the court held that this was the wrong approach, and that screening decisions had to be based on sufficient evidence of the impacts and the potential measures to be taken to address those impacts in order to make an informed judgment about whether environmental impact assessment is needed. In this case, the evidence that the Secretary of State had to hand when it was making its screening direction was highly limited in terms of the BSE issue. And you couldn't say with confidence that the conditions in this case were going to be effective, and therefore the planning permission was quashed. Turning to Packham, this is a challenge against the government's decision to continue with High Speed 2 following the review that was undertaken earlier this year. And one of the grounds of challenge was related to environmental impact assessment. It was a challenge that said that the decision to proceed with HS2 had been predicated on a misunderstanding about what the review had done. It was said that there was a flawed assumption that the review had assessed the environmental impact of HS2 when in fact it hadn't. And the Court of Appeal dismissed the appeal against the refusal of permission to bring judicial review in this case, holding that the government was under no misapprehension about the scope and the nature of the review in question. The review formed no part of the legislative process for approving of the project. It did not engage EIA legislation requiring the various procedures to be undertaken in respect of that legislation, because that had already happened. The review had not been asked to undertake a comprehensive reassessment of the environmental impact. And indeed, that is unsurprising, because such a task would have been unduly onerous and entirely unnecessary, given that the EIA had already been undertaken for phase 1 of HS2 prior to the Act coming into force. So there was no suggestion that and another thing that the court noted was that there wasn't any suggestion by the claimant of any new or different environmental impacts. The next case is Gathercole against Suffolk. This was a grant of planning permission for a new primary school. The issue at hand was the adequacy of assessment of effects of noise impact on a nearby airfield, and the impact of that would be on the future children that would be attending the school, and whether the effects of the identified alternative sites would be were assessed properly in the ES. Again, it was noted by the court there was no contemporaneous complaint about the adequacy of the environmental statement in respect of alternative sites. And again, the court was clear about what the directive actually requires. The EIA directive only requires an outline of main alternatives, and the main reasons for the choice of the chosen project, not a detailed assessment of each main alternative. And more importantly, that the sufficiency of information contained in an ES is a matter primarily for the decision maker, subject to Wednesbury review by the court. And in this case, the decision to choose the preferred site was not irrational, and any inadequacy in the environmental statement would not in any event have affected the decision. Girling, this is a case where it was a grant of planning permission for replacement facilities at Sizewell B nuclear power station. And these facilities, the intention was that these facilities, whilst currently being part of Sizewell B, would be would be effectively transformed into facilities that could then be used for the future Sizewell C station. And as many of you will know, the examination has not yet formally got underway in relation to the DCO for Sizewell C. So it was jumping the gun to some extent, but it was said to be justified in order to avoid future delays in respect of the implementation of Sizewell C. So to get the replacement facilities transformed over in good time now, so as to avoid holding up the project further down the line. The claim was that there'd been a failure to undertake the environmental impact assessment on the basis of up-to-date information. And the particular issue at hand was about the impact on breeding birds. And the court held that the duty to make the decision in relation to up-to-date information under Regulation 26.2 is not a duty to ensure that all the information in the case was up to date, but only that the reasoned conclusion on significant environmental effects was up to date. And it might seem like that's a slightly tenuous distinction, but I think it underlines the light touch review that will be undertaken by the court in evaluating an environmental statement. The council's view was that the bird information, the breeding information was sufficiently up to date for its purposes, and it was held that decision was not irrational. And so that particular aspect of the claim was not upheld. The very last case I want to talk about is in relation to the Secretary of State's own planning application for a Holocaust memorial in London, and it was a challenge not against the determination of that application, because we don't have the answer to that yet, it's still pending, but this was a JR brought against the handling arrangements for determining that application. So the EIA Directive requires that when you have an EIA of an application where the decision maker is also the applicant, you need to have sufficient standards of independence and objectivity and transparency, and ensure that there's a separation between the applicant and the decision maker to make sure that everything's above board. And there was a challenge in this case both to the failure to transpose the directive correctly in the EIA regulations, and then separately, even if there is adequate transposition, a failure to comply with the regulations in respect of the proposed arrangements at hand. And without going into too much of the details, the court held that there had been a lawful transposition, so Regulation 64.2 was not unlawful, but that there were issues in respect of the handling arrangements which could be improved in order to ensure compliance with Regulation 64.2. So there was a partial upholding of the claim. And I understand that those issues have already been remedied. You can find the handling arrangements online, and the inquiry into that planning application is going on, and we're yet to know the outcome. But it's a very interesting scheme, a very controversial scheme, of course, and we will await with interest what the result of that is. So I hope that was useful. That's a quick canter through 11 decisions in the past 12 months in respect of EIA and SEA. Thank you very much.